Good afternoon, and thank you for joining us today for 2021 legislative updates, HR compliance laws and alerts. For those of you joining us for the webinar for the first time, MP is a full-service human capital management company offering a suite of products and services including HR, payroll, benefits administration, time and attendance, and compliance. We support clients with cutting-edge technical solutions as well as proactive, reliable service and deep HR and payroll expertise. MP is wired for HR and helps clients succeed by aligning their HR strategy with their business goals. I'm Amy Weeman, Head of Marketing here at MP, and I'm thrilled to introduce your presenter today, Paul Carelis. He's our VP of Client and HR Services. Paul has over a decade of experience in HR consulting, working with businesses of all sizes and industries. Paul and his team of certified HR professionals at MP assist clients with compliance, training, and full circle HR guidance and support. And just before we begin the program, if you'd like to submit a question during the program, please use the Q&A feature at the bottom of the screen. And also, we'll be sending out a recording of the webinar later today via email along with the slide presentation. And with that, I'll turn the mic over to Paul.
Thank you, Amy. Thank you for that. And thank you for the introduction. Welcome, everyone, to today's session. This is a favorite of mine to do. We do these twice a year, once around January and once around this time of year. And when we're setting out our webinar schedule, we try to plan in advance pretty well and really try to predict what will be relevant. And when we were planning this one, it was probably a few months ago when we were still under a lot of COVID restrictions. Courts were shut down, agencies were mostly shut down. So I was honestly pretty skeptical with what we'd be able to talk about in today's session. But things aren't back to normal by any means, and we'll see what happens with the Delta variant and, if there are any more restrictions that go into play. But needless to say, the courts, the federal and state agencies, and the federal and state legislatures have kind of picked up where they left off pre-pandemic. So we do have plenty to discuss here. Just a quick legal disclaimer. This training is for educational, informational purposes coming from an HR best practices standpoint. Fortunately, we're not attorneys. Please don't construe anything today as legal advice. Everything we talk about today, as long as my fact checking has been accurate, should be current as of today, July 22nd, 2021. Also, another little disclaimer I'd like to give here on this topic in particular. We'll be talking about legislation. We'll be maybe making some predictions or guesses in terms of how legislation might go one way or the other. But we try to stay unbiased and not provide any political color to it, even though we are talking about politics and the lawmaking process. So in terms of what we hope to cover today, we'll do a general legislative overview, kind of a temperature check, let you know what the landscape looks like, as well as some major legislation being tossed around in the House and Senate. We'll talk about some recent Supreme Court rulings that have an impact on employment, as well as what's up at a couple of the federal agencies, the National Labor Relations Board, as well as the Department of Labor. We'll do a quick update on stimulus programs and where those currently stand. We'll talk about state laws. So we'll talk about some specific states and new laws that are going into effect this month in those places. And even if you don't have employees in those states, it's always a good idea to stay tuned to that kind of stuff, because often what will happen is a few states will sign on to something, it'll start a trend, and before you know it, the majority of states will have something similar. So it's just a good idea to have an idea of what the state law trends are. And then we'll gaze into our crystal ball a little bit, see what's ahead for the rest of this year, what we're seeing a lot of litigation on, and then kind of make some predictions in terms of what laws or rules we might expect to see in the year ahead. And as always, we'll leave time for any questions you may have. So feel free to jump on that Q&A portion of Zoom, and we'll get to those that we can at the end. All right. So in terms of the legislative overview, there's one really big piece of legislation passed the House earlier this year. It's now in the Senate, going through committee and debate and all that fun stuff. And just so you know, we'll talk about everything that's in the current version of the bill, but I think it's pretty universally agreed on that it's very unlikely that the bill as it stands right now would be passed as is. People have different thoughts in terms of what pieces of this are likely to pass, either through the PRO Act or through other separate legislation. We'll talk about that in a second. But this is what's currently being debated. So the PRO Act is a big one. It's all about labor, protecting workers' rights. So what it includes, first of all, is a challenge to right-to-work states. So in right-to-work states, what that means is even in a unionized environment, an employee can opt out of union dues. The PRO Act would change that. It would require anyone who's a member of a labor union to participate in terms of dues payment. It would also provide workers who are on strike some protections. It would protect them from being permanently replaced by their employer. While this PRO Act hasn't got a ton of coverage, one of the more notarized pieces is what's called the ABC test. So you may have heard of this in California, the Assembly bill that Uber and Lyft had a huge ballot initiative to compete against. But what the ABC test is really a test that's used to determine when somebody is an independent contractor and when they're an employee. So we'll talk about what the ABC test is on the next slide, but just take note of that. That is a big piece of this bill. The PRO Act, as currently written, would also change the definition of supervisor. So what a lot of this act is to open up opportunity for employees to be organized and to be part of a union. And in those scenarios, management supervisors are typically excluded from union membership. This bill would change the definition of supervisor so that more people that are currently considered supervisors and currently not included as unionized workforce would now be part of the union as well. This bill would also loosen the joint employer rules. So to state that employers who have direct or indirect control over a worker could potentially be a joint employer. This comes into play in temporary work scenarios, work assignments, things like that, franchise situations where the temp agency might be sending someone to go work at a warehouse for another company. It might be a corporation who has franchisees and how the franchise treats their employees or what wage and hour laws they're observing. When there's a joint employer scenario, both parties share some responsibility and potentially liability there. So should joint employer rules be loosened, and let's say a staffing agency sends someone to work at a warehouse, if that warehouse is not following labor laws of some sort, then the staffing agency could partly be held liable as well. There's also a lot in there about election rules for companies attempting to unionize. It would reintroduce quickie elections, which can result in as quick as an eight-day turnaround time from when the process is started to when the election takes place. It would also allow employees to use company email for purposes of collective bargaining and unionization. And it would ban companies, employers from holding what are known as captive audience meetings. So captive audience meetings are when a company says there's a mandatory meeting that everyone needs to attend. These typically take place during the process of a company considering becoming unionized, and it'll give the employer the opportunity to speak to the employees as a mandatory meeting to try to dissuade them from unionizing. So should that piece of it pass, captive audience meetings would be barred. The PRO Act would also limit mandatory arbitration. So in those cases when an employee feels wronged or grieved or terminated for wrong reasons, some businesses will have mandatory arbitration clauses that say those disputes have to go to arbitration rather than the courts or agencies. This would bar that. It would also create required postings for an employee's Section 7 rights. So that has to do with the National Labor Relations Act, but those come into play a lot in terms of an employee's rights to discuss the conditions of their employment, their rights to organize, all that kind of stuff. So it would just be kind of a new workplace poster. And then finally, the PRO Act does introduce some punitive damages and civil penalties to employers when they violate labor rules. So under the National Labor Relations Act and the National Labor Relations Board, who governs it, usually when damages or fines are doled out from an illegal employment action in terms of the National Labor Relations Act, the damages are usually minimal. They're just to bring things up to code and get things compliant. This would change the game quite a bit and really introduce some big money penalties for employers who violate employees' rights under the National Labor Relations Act. This piece in particular has a very good chance of passing. There's a lot of talk right now of moving it out of the PRO Act and including it in the budget bill that's going through reconciliation right now. So the budget reconciliation bill is looking very likely to pass, and there's, again, a lot of talk in Washington right now of adding in the monetary penalties for labor violations to that. So more to come there. So just to review the ABC test in a little bit more detail, the ABC test is a three-pronged test, and in states or jurisdictions where it is in effect, a worker would have to meet all three of these criteria to be considered an independent contractor. If the worker does not meet all three of these, then they would be considered an employee. So the first prong is the worker is free from the control and direction of the hiring entity in connection with the work's performance, both under the contract for the performance of the work and in fact. So this really has to do with that whole control definition. That's pretty standard when it comes to defining employee versus independent contractor. You know, how much direction is the worker given in terms of how the work is performed, when, where, what have you. The second prong is that, and this is a really important one, and this is what disqualifies workers from being considered independent contractors in many situations. The work being performed is outside the company's usual course of business. So that was the big argument with Uber and Lyft, is that, you know, the debate was, is Uber and Lyft a ride sharing service? And if so, you know, driving is part of the course of Uber and Lyft's business. They were more relating themselves to being, a matching service, connecting people who want to ride to people who want to drive. But that's been quite fraught in the courts. But this comes up in a lot of other situations as well. Freelancers that are working for any sort of company, if the work that they're doing is related to the company's main mission, then it would run afoul of the ABC test. And then third, the worker is customarily engaged in an independently established trade, occupation, or business of the same nature as the work performed. So this has a lot to do with economic dependency on the gig that they're working. So if they're a driver and they drive for, you know, other people other than the person that's paying them in this arrangement, that helps. But, you know, if they're doing work for this company and solely for that company, and they're not doing or not able to do or not allowed to do that same work for other people or other businesses, then that would also jeopardize them as an independent contractor in an ABC test scenario. So these rules are in play in California. They're also, it's called a three-prong test in Massachusetts, but the same test is in place in Massachusetts as well. But many other states do not follow this, but changes either whether it's through the PRO Act or Department of Labor action that may follow. This would change the game for a lot of businesses and their independent contractors. For those of you wondering, Uber and Lyft did succeed in their ballot initiative last November, so they did kind of get a carve out. They were exempted from this, and they're allowed to operate as they were, with some exceptions. Okay, now for a quick COVID update. Many of the stimulus programs that were passed over the last year and a half or so are set to sunset or expire September 30th, so the end of this quarter. That includes the COBRA subsidy program, the American Rescue Plan COVID sick leave program, as well as the unemployment premium for states that are still allowing that. Many states did drop off and stop that unemployment incentive. They felt it was hurting the unemployment numbers and the ability for businesses to rehire employees. But those all formally end as of now at the end of September. Again, should infection rates rise or something like that, they could look to extend those, but as of right now, those will all be ending 9/30. We get a lot of questions about new rounds of PPP or other grants or funds. As of right now, at least at the Washington level, there haven't been any serious talks or bills proposed that would create new stimulus money for the business world. We'll keep our eyes peeled for that and certainly let you know if that changes. For those of you who are looking for additional revenue streams or assistance in terms of funding, if you haven't already, I do encourage you to look at the Employee Retention Tax Credit Program. They did change the rules for that. If you're a fan of our webinar series, you've undoubtedly attended a webinar on this topic, but if not, you can certainly go ahead and look at our website. We do have a ERTC playbook that's either just released or soon to be released, but we are working with businesses on ERTC, and a lot of them are realizing some pretty hefty refundable tax credits. So worth looking into if you're searching out new funding options. We will have a webinar on the 30th of September all about kind of coming out of the pandemic. Hopefully that is still the tone by then, we'll see. But just talking about in a little bit more detail, the ending of these programs and some strategies for kind of how to enter the next chapter of the business world. So that'll be September 30th. Okay. Let's move on to the Supreme Court and the federal agencies. So Supreme Court has been busy over the last few months, and they have had some significant Supreme Court rulings that do impact best practices and employment law. The first of which was a victory for agricultural businesses. There was a case involving some union organizers who were kind of coming unannounced to farms and agricultural work sites. The company challenged that, and the Supreme Court sided with the company that they aren't allowed to do that. So there are now restrictions in terms of unionization efforts in agricultural scenarios. One interesting one, and it's important to note that this had to do with a school and a student, but a lot of experts are also saying that this could potentially apply to workplaces as well. So there was a student who was expelled or removed from a team because of some vulgar TikToks that she posted on her own time, in her own home. The Supreme Court found that was overreach, that it violated her protections for free speech. So as you can imagine, that does make people wonder and take a look at their social media policies and wonder, how much teeth those now have given the Supreme Court ruling. So my advice generally to clients is, let's play it safe. Let's play it conservatively. We'll let someone else spend the legal fees to be the next precedent case. But this was an interesting ruling and could very well apply to workplaces as well as schools. And the Supreme Court also continues to hammer home religious liberties for religious institutions. So allowing them to kind of make their own rules if they have to do with that religion and the norms of that religion. So requiring employees to teach things a certain way or to be of a certain denomination. Certainly there was a lot of media coverage of the ability for businesses or religious organizations with closely held religious beliefs to limit or restrict contraceptives from their insurance plans, things like that. So the Supreme Court did rule, and this was specifically for a religious agency, an adoption agency, and their restrictions on same-sex couples as adoptive parents. The Supreme Court did rule in favor of the religious institution, so that kind of continues things on the path of the current court giving more power to religious entities to kind of run businesses and employment practices as they wish. There was also a very interesting case that covered the Computer Fraud and Abuse Act. So in the case, it had to do with a police department and a sergeant who had access to a system to run license plates and garner information from those license plates. So what he did was he gained information that he shouldn't have unauthorized of people based on their license plates to kind of do his own little PI work or on the request of someone else. He gained personal information about people that wasn't in line with the work that he was doing as a police sergeant. And in somewhat of a surprising move, the Supreme Court actually ruled in favor of the employee, stating that when someone has authorization to a system, that it's not necessarily, in terms of the language in the Computer Fraud and Abuse Act, it's not necessarily unauthorized if they are authorized to view it, and it isn't criminally illegal for them to do so if they're otherwise authorized, if they access information that might not be intended as part of their work. So my interpretation of that, and again, this isn't legal advice, is that there still would be the opportunity for employment action and disciplinary action and termination, but in terms of criminal liability, that's where the Supreme Court really drew the line in the sand with this case. Okay. Over at the National Labor Relations Board, a lot of changes over there. So for a while now, there had been a vacancy on the board. So it's typically a 5-member board. It had been operating as a 4-member board for, again, quite a while now. So they did get deadlocked on some things, but that is all changing now. President Biden has made two new nominees to the board. So one to fill that vacancy and another to replace a member of the board whose term is up in August. Once that happens in August, control of the National Labor Relations Board, as it does historically, will shift to Democratic power. It'll be a 3-2 majority in favor of the Democrats. President Biden also did get approval on his nominee for general counsel of the National Labor Relations Board. Her name is Jennifer Abruzzo. And as we've said in previous iterations of this presentation, that general counsel seat is very, very powerful. So that position ultimately decides which cases the board wants to hear. And when you look back historically, it'll be a lot of back and forth. So, the Obama-led National Labor Relations Board looked to revisit rulings during the George W. Bush National Labor Relations Board and weigh in on those, and sometimes reverse the way of thinking. The same thing happened when President Trump came into office. They selected certain cases that were close or identical to cases that the Obama NLRB had ruled on, and reversed some decisions and some way of thinking there. They also released a series of memos to let the country know where they stand on certain issues and how they will rule and how they will judge certain situations in relation to the National Labor Relations Act. So what the current board has done so far is they removed 10 of the Trump era memos. We'll get into those in a second. One important note before I skip over it, when President Biden took office, he asked the acting general counsel to resign. That general counsel refused, so he was terminated. There was a lawsuit around that, but I think it was just a week or two ago, a district court ruled in favor of President Biden, saying that termination was lawful. So he was okay to proceed with Ms. Abruzzo for the new general counsel role. So some things to look for, especially in regards to the memos that were rescinded. Handbooks is a big one. So the National Labor Relations Board does tend to like to review handbooks and handbook policies to see if there's anything in there that could be a violation of an employee's rights or chilling to their rights under Section 7 in terms of their rights to organize, their rights to discuss and have concerted protected activity, discussing the conditions of their employment and things like that. So there was a memo during the previous administration, NLRB, that kind of said, hey, we're going to, when we review handbooks, we're going to go into them thinking that the businesses is doing these in good faith, and it'll really need to prove that a policy is strongly chilling of an employee's rights or a strong violation of employees' rights before we take action. That has been rescinded, so the tune to that may change. National Labor Relations Board is always intertwined with union rules, so it'll be no different there. It'll just be different people examining it. Another one of the memos that was rescinded had to do with whistleblower protections. So the previous memo talked about giving employers the leeway to kind of give a warning to potential whistleblowers that they could be in trouble if any footage or evidence that they are coming forth with was obtained illegally. That's being removed, so there will be stronger whistleblower protections moving forward. But this is something to keep an eye on. There could be a lot of action at the NLRB starting in August. And the other one, so despite the 4-member board, they did vote last week 3-1 to allow who you see here, Scabby the Rat, to remain on work sites when there's a strike going on. So there have been a few court cases over the last year or two to fight having this large inflatable rat present when there is a workplace dispute. So the NLRB did, again, recently rule that Scabby the Rat is an allowable presence at work sites, in case you were curious. Over at the Department of Labor, it looks like Marty Walsh is going to stick it as the labor secretary. There was a little bit of controversy in regards to his time when he was the mayor of Boston, and some of the activity at the police department and some of the personnel there. But it does seem like he will remain in office as the Secretary of Labor. President Biden did just within the last couple of weeks have the deputy secretary and the solicitor, so those are kind of second and third in command. His nominees for those roles have been confirmed, so we do have kind of a full compartment at the top within the Department of Labor. This usually means that once those slots are filled, they'll start to be a little bit more productive, efficient, and you'll see more coming from them. They have released a few proposed rules. So the Department of Labor observes the federal rulemaking process. They propose a rule. There's then a comment period for the public to make comment on it. They then come out with the final rule, and then it's published in the Federal Register and becomes the rule of the land. The most recent proposed rule, which came out this month, calls for a $15 minimum wage for federal contractors. So that comment period is going on right now. There's another proposed rule that came out, I believe, last month, which would create changes when it comes to tipped workers. And specifically, when an employer can pay the tipped minimum wage and when they're prohibited from doing so. So there's been a lot of back and forth on this federally. And again, similarly, this has bounced from administration to administration, and the rules have changed depending on who and what party is in power. It's not new, but it's being reintroduced as part of this proposed rule. You'll see here the 80-20 rule. And what that means is that tipped employees, wait staff in restaurants, things of that nature, can generally be paid a tipped minimum wage, which is lower than the standard minimum wage, provided that the tips that they receive make up for that difference. For any of you who have worked in the industry or in another tipped role, you know that not 100% of your time is spent doing kind of tipped work, waiting tables. You're doing prep work. You might be rolling up silverware. If you're a bartender, you might be doing some inventory, things like that. What the 80-20 rule says is that if more than 20% of your time is being spent on these non-tipped tasks, or more than 30 consecutive minutes is being spent on these tasks, then that time must be compensated at least the full minimum wage, and that employers cannot pay the tipped minimum wage for that time if it's going over that 20%. So again, this is in the proposed stage. It's open for public comment, and then they'll get to work on the final rule. Do note here, many states have their own rules in terms of tipped minimum wage, tipped overtime, things like that. So if and when this does become a formal, final, official rule, whichever version, state or federal, is more friendly to the employee is what will take precedence wherever you're doing business. President Biden also did announce in his fiscal year 2022 budget a large increase in budget, especially for OSHA, which is technically a part of the Department of Labor. So increasing the budget of OSHA by $70 million, most of that earmarked towards building up the staff there. There are currently 188 employees of the federal OSHA department. Secretary Walsh is looking to get that as high as 639 employees. Part of that will go towards assisting businesses. They've got a really nice program, if you've ever wondered or wanted to look into it, to have OSHA come in, not as an auditor and not with the ability to fine, but to do kind of a pre-examination and let you know if there are potential OSHA violations and give you the chance to remedy those without going through any types of fines or penalties. But there will certainly be a lot of that staff dedicated to enforcement and to audits and to the less likable arm of OSHA. OSHA has also introduced their agenda for the remainder of this year over the next 6 months, and where they want to focus their efforts. They're going to be coming out with some more formal heat illness prevention procedures and expectations. So for workers who are exposed to the elements, either indoors or out, and what the guidelines and requirements for employers are around that. They're also looking to do expanded and enhanced injury and illness tracking for workplace injuries. So there'll be more on that to follow. And then also some regulations regarding personal protective equipment, or PPE, which we've all become familiar with during the pandemic, but specific to the construction industry and what employers' requirements are in terms of providing PPE. The Department of Labor also did recently release their strategic goals that they hope to accomplish over the next 4 years, so fiscal year 2022 through 2026. And at a high level, these are what they are. The first is to build opportunity and equity for all. The second is to ensure safe jobs, essential protections, and fair workplaces. Goal 3 is to improve the administration of and strengthen worker safety net programs. Goal 4 is to be better at measuring statistics and data. And then overall management of the department to be grounded in evidence, innovation, and employee engagement. They did release a PDF file. It's kind of a funky looking pictogram where they go into a little bit more detail and have some kind of sub goals within each of these goals. If I can, I'll include that in the copy of the slides and the recording that we send out later today, just in case anyone's curious about where the Department of Labor's head is at and where they may look to create new rules. All right, let's take a look at the states. What's going on over there? So as many say, July 1 is the new January 1. There are several states and several regulations that did take effect this month. This is a review of some of the most significant. Virginia and Pennsylvania have passed living donor leave laws. So basically, if someone is an organ donor, they're given job protected leave to take care of that. There have been decriminalization and legalization of marijuana laws that take effect this month in Connecticut and in New Mexico. There's a lot going on in terms of pregnancy and childbirth protections, whether that's a requirement for employers to provide reasonable accommodation or protected leave in cases of pregnancy and childbirth. The states that were active on that taking effect this summer are Arizona, Kentucky, Georgia, and Indiana. And then several states have also created new protected class groups. So in Colorado, gender identity and gender expression join the list of protected classes there. Arizona has adopted pregnancy and childbirth as a protected class. Virginia has added military membership or being a military spouse as a protected class. And New Mexico has expanded their race protected class to include hair, meaning hair length, hair styles, and hair texture as potential for a protected class under race. And what this means are when we talk about protected classes is when someone or something can be the basis of discrimination or harassment. So if you've attended a previous educational session from us, you know that in order for something to be considered legally discriminatory or legal harassment, among the qualifiers is that it has to be based on a protected class. So now people who fall into these protected classes could potentially have a case of discrimination or harassment. And then also New Hampshire included as part of their budget that was passed by Governor Sununu an optional kind of paid family medical leave program. So this is going to be optional for employers to either opt in or not. The state and their employees are going to be mandatory participants. They're going to serve as a risk pool. But there'll be more information on this to follow, I'm sure. But if you are a New Hampshire employer, something to look out for. And if you are looking to offer this, there will be an option to you. Okay, so oftentimes I'm asked to gaze into my crystal ball and predict what the next several months or year ahead might look like in terms of employment law and litigation. So let's go ahead and do so. So in terms of litigation trends and what we're seeing when we take a look at employment law action that's hitting the courts, these are what I'm kind of seeing as the most common case topics. First of which is COVID, employees feeling that their employer put them at risk in some way by not taking proper safety measures to protect the workplace. We're also seeing a lot around wage and hour, a lot regarding overtime. So both litigation and Department of Labor action. There was a pizza restaurant, a 2-location pizza restaurant up in New Hampshire who just had to pay $140,000 to delivery drivers, and they were paying overtime, they just weren't paying it at the right rate. So it's important to note that overtime calculations have to be made at the regular rate, which counts most, if not all, compensation received, not just their standard driver wage or tipped rate. So it's important if when you do have tipped overtime or other unique overtime situations that you make sure you're calculating overtime correctly, because again, both the Department of Labor via their actions as well as employment lawsuits that we're seeing do pick apart overtime and how it's handled. Also a lot with misclassification, whether it be a worker saying that they were paid as an independent contractor when they should have been paid as an employee. Also, employees who are paid as exempt salary workers who feel they should have been entitled to overtime. And this ties in with the next bullet point, remote work. So as businesses went remote, as they had workers performing work from home without any direct physical oversight of what they were doing and when they were doing it, you're seeing a lot of cases pop up where an employee who was either non-exempt and paid hourly or should have been paid hourly and eligible for overtime was doing a lot more work, working over 40 hours in a week and not being compensated for that overtime. So something to be mindful of, especially if you're continuing in a remote work environment as we kind of move on from the pandemic here, that you're taking all appropriate measures that you reasonably can to have an idea of what hours your employees are working, especially if they're not exempt, and making sure that you're following all wage and hour laws, especially with overtime there. Also a lot regarding accommodation, so things like the ADA and disabled workers, and making sure that it's really important if you perceive or know of an employee that has a disability that you enter what's called the interactive process, because there's a lot of court cases going on right now where there are claims that employers did not go through the necessary hoops to provide reasonable accommodation to their employees. So be mindful of that. And then a lot with harassment, hostile work environment, and where historically a lot of these have been sexual harassment cases, we're seeing a lot more regarding other protected classes. So harassment and hostile work environment cases having to do with race, having to do with disability, having to do with gender identity, things like that. So those are really the hot topics right now. Another thing to be mindful of when it comes to being compliant, a lot of businesses received a pass from the states that they work with and where their employees live when it came to taxation and what state to tax an employee in. Most states allowed kind of the status quo to continue during the pandemic, that if I used to work out of an office in South Carolina, but I live in North Carolina, and I've been working from home out of my home in North Carolina, it was generally okay during the state of emergency and during the pandemic for me to continue to be treated as a South Carolina employee. As states of emergency are expiring or being rescinded, as things are quote unquote returning to normal, a lot of businesses have found that remote work is a good option for them. Their employees may really like it. They may want to appease those employees and allow them to continue to work from home. But if that work from home is out of state, states are now starting to enforce and reminding businesses that now that the pandemic is over and these, there aren't any excuses, I guess I should say. So if you continue to have employees now working out of state, you probably need to examine that, and you may have to register for, at the very least, payroll taxes in those states. Okay, so some things to look for, whether it be government agency action or new laws at the federal or state level. Definitely expect some action on independent contractors. So if the PRO Act kind of dies out, if that doesn't end up being passed, do look for the Department of Labor to tackle that issue. It might not be until next year, but it does seem like the current administration is interested in trying to move towards that ABC test across the country. So there will likely be some movement there. More and more states are moving towards legalizing marijuana. There is even talk at the federal level of legalizing it across the country. So you'll want to make sure that your policies are clear when it comes to marijuana usage, if it is legal in the state that you're operating in or other states where you do business, especially as a controlled substance. We'll see if federal legislation does pass, what rights that gives to employers to mandate that. But at the very least, even if the rules are lightened, it might be something that you treat as alcohol. So you just want to make sure that your employment policies address marijuana in the workplace if it is legal in your jurisdictions. Another interesting one is there was a recent court ruling. I forget what state it was. It was either Idaho or Iowa, but they did deem CBD oil as a controlled substance. So if that's something you care about and again, wish to address and want to limit usage of CBD in your workplace, that's also something you want to specifically address in your policies. Given that the Secretary of the Department of Labor, as well as other people in the administration, have a union background, there's going to be a lot more focus on unionization and collective bargaining rights. Also expect to see new laws and focus on pay equity, both gender equity when it comes to pay practices, as well as other protected classes. More and more states are taking action in terms of the ability for businesses in terms of COVID restrictions or looking ahead other future pandemic restrictions and vaccination rules and vaccination mandates. The EEOC, which is a company we didn't have an update on this time, but they did recently state that employers may have mandatory vaccination policies that provided they provide accommodations to those who need it, either for religious or medical exemptions, that they can otherwise proceed with mandatory vaccination policies. And then more and more states look to limit the power and the jurisdiction of non-compete agreements. So that's something that's kind of evergreen on here, but more states continue to talk about and pass legislation restricting or eliminating non-compete agreements. And I know especially in the small to mid-sized business community, those are common. So make sure if you do have a non-compete agreement that it is valid in the state you're operating in. Okay. In terms of questions, it looks like we've got a couple. One regarding overtime for tipped employees. So that varies a lot by state. Here in Massachusetts, they have one of the more unique tipped overtime rules, which changed a few years ago. But it all has to do with the tips and the tip credit that an employer is allowed to take. One other thing I can include for those of you, it does look like we do have several people in the hospitality industry and as well as some Massachusetts-based, or at least with locations in Massachusetts, where the Massachusetts tipped overtime law is so unique. I can include in the communication we send out later today with the recording and with the slides, the Massachusetts Restaurant Association has a really nice kind of breakdown of the minimum wage, what the tip minimum wage is, and then what the tipped minimum overtime rate is. So I'll be sure to include that for people who are local here to Massachusetts that could benefit from that. But in terms of other states, it really depends on what the tip minimum wage is in that state and what they allow for a tip credit, and then how the overtime works there. But if you do have questions, if you are in other states and want to know about tipped overtime, feel free to reach out to us and we can help out with that. Okay, then we have a question here about termination and return of equipment. So when it comes to that, whether, and the question here is whether it's okay to verbally communicate that or if it should be in writing. Most states do allow for termination to be completely verbal without a termination letter. And they can similarly verbally request the return of equipment. Hopefully they're keeping track of their company assets. For those of you who are current MP clients and use iSolve, there is the ability to track company assets down to the serial number within the system by each employee, which is something I always recommend to clients they utilize. But depending on what state it is, there are a handful of states that do require written termination letters and do require a reason for the termination, and as well as any terms, including requirements to return equipment. But in terms of being compliant, again, in most states, doing it verbally is okay. It is always the best practice, and we do always highly encourage employers to document things like that. And it looks like we do have one other question about the New Hampshire paid family medical leave and if there's a wait period. We're just getting our hands on that. It was just included in the budget. So we will have a lot of content on that coming out once the guidelines are a little bit more clearly defined. But unfortunately, I don't know the ins and outs of that new program just yet. So it looks like those are the questions we have. I thank you very much. I will hand things back over to Amy to close us out.
Thank you, Paul. That was an abundance of information. Thank you all again for attending this webinar. We hope you came away with some helpful information on the latest HR legislative updates. I want to quickly remind everyone that a link to the recording and the presentation will be sent out in an email later this afternoon. Please join us next week. We have 2 really great webinars on the schedule. On Tuesday, Paul will be back again with the latest on employee retention tax credits, how to determine if your business is eligible, and how to maximize your credits. And then on Thursday, we have Sherry Heller, another one of our MP HR experts, covering Mass PFML with a focus on avoiding discrimination and retaliation penalties. For a complete schedule of all our upcoming webinars, visit our website on the resources page. Thanks again for joining us today, and have a terrific rest of your day.